Subscribe to our YouTube channel and press the bell icon to get the latest updates.
Now, a few High Court judgments over the past month or so have brought the focus back on marital rape, and there's a growing clamour to criminalize it and bring about a change in the current law. So, in this episode of KYC or Know Your Constitution, I'll explain three things to you. I'll explain to you what the law says, what the courts have said about it, and and also about a constitutional challenge that is currently pending in the Delhi High Court against this law. Now, to talk about the law, it is basically section 375 of the Indian Penal Code that defines the offence of rape. And within this section, there are two exceptions to rape. Now, exception 2 is what we usually talk about, and it says, and I quote, sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15 years of age, is not rape. So this is the exception that carves out basically an exception for marital rape within the Indian Penal Code. So in simpler words, what the text of this provision means is that marital sex with a woman who is over the age of 15 years is not rape, even if it is without her consent. Now, the Supreme Court has in the past turned down several petitions that have sought criminalization of marital rape several times in the past. There have been petitions that have come up, but it has time and again said that this isn't in the court's jurisdiction, it isn't for the court to decide, and that it is for the parliament to take a call on it. In July 2019, in fact, the Delhi High Court had also turned down a plea. This was a PIL that sought a direction to the central government to declare marital rape as a ground for divorce. But once again, the court turned it down, saying that it cannot direct the parliament or tell the parliament what laws to frame, because that is within the domain of the legislature and not the judiciary. There is one challenge pending to it though. There are actually quite a few petitions that have been clubbed together, and that's pending in the Delhi High Court, and I'll be telling you more about that in this video. Here, I'd like to talk about another landmark judgment by the Supreme Court in 2017, which came around this exception. So like I mentioned earlier, the exception in the Indian Penal Code, the IPC, says that marital sex with women over the age of 15 is not rape, even if it is without her consent. But in 2017, the Supreme Court ruled that sex with one's minor wife who is below 18 years old would amount to rape, even if it was with her consent. This effectively means that the law in the country now penalizes marital rape only where the wife is below 18 years old. So basically, the Supreme Court, with its interpretation, changed the age limit from 15 to 18 years within the Indian Penal Code. As for marital rape as a ground for divorce, we had a landmark judgment by the Kerala High Court very recently. It was pronounced last month. It basically ruled that marital rape is in fact a valid ground for divorce. And in this judgment, the Kerala High Court actually made some very strong remarks. Basically, it ruled that just because the law does not recognize marital rape as a crime, basically under IPC, it still falls within the framework of physical and mental cruelty, and cruelty is a ground for divorce in India. The court basically said that in modern social jurisprudence, spouses in marriage are treated as equal partners, and that husbands cannot claim any superior right over their wives. In this case, just to tell you a little bit about the case, in this, the husband was a doctor turned realtor, and the wife had alleged that he forced her to have sex with him when she was sick and bedridden, and on the day of his mother's death. He also allegedly forced her to have unnatural sex and engage in sexual intercourse in front of their daughter, and he, on the other hand, had accused her of having illicit relationships, basically accused her of adultery. But almost a month after this Kerala High Court judgment, which was celebrated throughout the country, came an order by the Chattisgarh High Court. In the Chattisgarh High Court judgment, what happened was a woman had filed an FIR against the husband and her in-laws for harassing her for dowry and for being physically violent with her Now, the lower court had framed charges against the husband under various provisions, one of which was Section 376, which talks about the punishment for rape. The woman had accused her husband of unnatural sex and raping her with objects as well. But the High Court now discharged the husband from the offence of marital rape, saying that sexual intercourse, and I quote, the court said that sexual intercourse or any sexual act with her by the husband would not constitute an offence of rape, even if it was by force or against her wish. But the court did go ahead and sustain the charges against him under Section 377 of the Indian Penal Code. There was a lot of criticism of this order over the past few days, but many experts have since pointed out that blaming a court here isn't the solution, because courts are helpless when it comes to application of the law. So up until this law actually remains in the statute books, courts will be bound to apply it. But there's another point to be noted here. Now, several news reports call these two judgments, the one by Kerala High Court and the one by Chattisgarh High Court, as conflicting verdicts. But just to be clear, these two cases are different in the sense that the Kerala High Court case was a divorce matter, while the Chhattisgarh case is a criminal case. So the application of law in both the cases was extremely different. Now, like I had mentioned, there is a challenge against this exception to Section 375. This challenge is pending in the Delhi High Court currently. Now, we have a petition against this filed by the NGOs RIT Foundation and the All India Democratic Women's Association, represented by Advocate Karuna Nandi, and a survivor of marital rape, represented by Advocate Colin Gonsalves, who have sought striking down of this exception in the Indian Penal Code that I told you about as unconstitutional. Now, these petitioners had asserted that the marital rape exception violates Articles 14, which guarantees equal protection of law, Article 15(1), which talks about non-discrimination on the grounds of sex, and Article 21, which talks about the right to life and liberty under the Constitution. In fact, in one of the hearings, we also had Advocate Karuna Nandi arguing that the exception falls foul of the concepts of bodily integrity and sexual autonomy, therefore violating the right to privacy as well. And we know that a 9-judge bench of the Supreme Court in the Puttaswamy judgment had affirmed that privacy is a fundamental right under the Constitution, under Article 21, which guarantees the right to life and personal liberty. Plus, in addition to this, the petitioners have also contended that the exception infringes on a married woman's sexual identity and expression, which have also been held to be integral elements of the right to freedom of speech and expression under Article 19(1)(a) of the Constitution. This was by the Supreme Court in the 2014 transgender rights judgment, which is the Nalsa judgment. In response to this petition, in August 2017, the centre had filed an affidavit in the High Court saying that marital rape cannot be made a criminal offence, as it could become a phenomenon that may destabilize the institution of marriage and become an easy tool for harassing the husbands. It had also said that since marital rape isn't defined in the statute books, in the laws, such an exercise would call for a broad-based consensus of the society. And the centre even went on to say that what may appear to be marital rape to an individual wife, it may not appear so to others. And as to what constitutes marital rape and what would constitute non-rape needs to be defined precisely before a view on its criminalization is taken. Now, the petitions against marital rape last came up in January 2020 and they were posted for hearing for 27th March 2020. But of course, by then, COVID had already struck India, leading to the nationwide lockdown. So the petitions haven't come up since and they're currently pending. This is Apoorva Mandhani for ThePrint. Do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.